I'm Hank Parrott, your host. Just before the break, I was given to Russ here about about to ask Russ a question about how this works with the new changes with the Secure Act. And in particular, Russ, now people have to cash out these retirement accounts in 10 years, but sometimes that can be counter if they're looking to not only have the asset protection feature, but in particular if they want to keep it in trust. So what's some strategies that you employ there?
Well, it used to be that we would set up these trusts at what are called conduit trusts. What that means is the IRA is taken out over the life expectancy of the child, and the monies go into the trust, and the trustee passes it directly to the child. That's no longer the case. The Secure Act has changed the rules. They say you can't do that anymore. They require us to pull it out over a 10-year period. So now these trusts that we're creating for the kids are called accumulation trusts. So they still qualify for the IRS look-through provisions, meaning you look through to the child to determine how much or how little you have to pay out. And we're still under the 10-year rule when they go into this trust. So the trustee pulls the money out over a 10-year period, and then the trustee has the ability to either hold the assets in trust, the monies that are pulled out from the IRA, to hold them in trust. If there's an issue with a child being in a divorce or bankruptcy situation, or if not, then they probably most likely distribute them out to the child. But we want to maintain that flexibility so that if we run into a scenario where we have to keep it in trust, we have the ability to do that. So I guess this is a pitch for making sure your estate planning documents are reviewed on a periodic basis, because I know most of those trusts that were set up prior were set up as conduit trusts that may not work well for the client at this point.
This is one of those areas, you know, when it comes into your planning, there are a lot of different things that we haven't covered. There are a lot of advanced strategies that can be used. And Russ, some of those, you know, credit shelter trusts, personal residence trusts, GRATs, GRITs, charitable remainder trust, charitable lead trust. You talked, in fact, recently, I think we talked a little bit about the differences between a charitable remainder trust and a charitable lead trust.
Yeah, the charitable lead trust is one that we use if we're looking at an estate that is going to be subject to estate tax. After doing all these other maneuverings, it allows us to reduce the estate that's subject to the tax to zero, because what the trust says is you pay out a certain amount to a charity, your donor advised fund, over a certain period of years. At the end of that period, the funds go back to the kids, and the way the numbers work, that's a complete charitable deduction on 100% going in, and yet the growth ends up peeling back to the kids. Charitable remainder trust can be used for IRAs if you want to stretch it out over more than 10 years.
So there are other tools, and I'm sorry we just don't have time to get in all of them today, but to understand that there are other tools available when it comes to trust planning with regard to your estate plan. Things where if you've got charitable intentions that you want to have take care of certain charities, that there are different ways that you can do that and receive some tax advantages potentially during your lifetime. Or that can help reduce the taxation on your estate going to your children. A lot of strategies. Again, no time to cover them all. I hope this has been helpful for you this week. I know it's a lot. Again, give us a call if you need any additional help, and join us here